So how can you come across $34.7 million? Well, one way is to win in a lawsuit against your employer. That's what happened in this case. I'm Brian Jackson. Welcome to Law Up. We're going to talk about this verdict that just came down today from California in an employment case where an employee was awarded $34.7 million in a defamation case. We'll talk a little bit about the facts and then about defamation and how they prevailed on defamation and how it's tricky to make a defamation claim against your employer. And then also we'll talk a little about big picture stuff and really what was going on here and what Wal-Mart was trying to do and stuff about workers' compensation, and we'll go from there. So this case, $34.7 million, and the facts of the case essentially are, from what I understand, looking at the complaint, looking at articles, and then looking at the jury award verdict, is he was working for Walmart, and the complaint talks about how good of an employee he was and were any performance issues and no bonuses. He always received his bonuses, and he was such a stellar employee that they put him in some promo videos with Walmart and some other stuff. And then at one point he was driving home from work or something in his vehicle. I think he was about to go on vacation or something too. And this semi truck ran into the back of him and hurt him. And then he had to go on workers' comp. And he was trying to figure out workers' comp and trying to get leave to get off work based off his injuries. And then out of nowhere, his employer said that he was terminated for fraud and gross misconduct. And so he was kind of floored by that. Then the other issue is that was in his termination letter notice. And I mean, that's kind of a no-no especially in California, giving a basis for terminating someone. But in California, I mean, maybe their in-house counsel with Walmart was wanting them to have a specific reason not related to like a disability or something. And so just saying, oh, well, we're terminating you because of this. And the issue was when he applied for another job, he had to tell the job he was applying for that he was terminated because of that. And so that led to damages. And so he had a valid claim at that point where the false statement affect monetary value as far as him getting compensation, and also just the fact that he was terminated too. And so in defamation, I had done a podcast on defamation, but just quick summary, what you have to prove. And defamation, slander, libel, it's all pretty much the same thing. Slander is just the false spoken word. Libel is the written spoken word, and defamation is both. But essentially what it is you can't say anything false to a third party about someone else that lowers their reputation in the community and causes some kind of monetary value damage. So here there's definitely monetary damage because he wasn't able to get employment and he lost his job. So he's got lost wages and benefits and also potential future job lost wages and benefits. And so those are actual damages that he could recover from. But also what's tricky in a lot of states, they give immunity to companies in scenarios when they're doing investigations. And the purpose and principle behind that is, say some employee doesn't like another employee and they say something completely false. And I guess the principle is you don't want to put the company on the hook for some crazy employee gone rogue. So most companies or most states have laws that protect the companies from those statements where they have some kind of immunity and during part of an investigation. But where a company can get on the hook in a lot of states is where if they incorporate that statement as if it's the statement from the company. So if in the end they do an investigation and they find out that it's false, and they incorporate it, and so it's essentially the company saying it now, then you could have defamation, and you just could make sure that it's been communicated from one person to another. So if it's just your boss telling you why you're terminated and they didn't tell anyone else within the company, then there may not be defamation. And some companies try and claim too that a company is its own entity, its own creature per se, and so that they can only, it has to be communicated outside the company. I've seen those arguments before. I don't think those really gain traction. I don't think that's really what you have to prove, and it just has to be communicated from one person to another. It's false, but I have seen those arguments before, and but also with that immunity that I talked about, if they incorporate it as their own and it's false, they could still have an argument to say that, hey, we tried our best in the investigation, and after talking to everyone, that's the result that we came up with. And so with that, there's kind of a higher standard with companies typically that you have to prove. You have to prove there's malice. And so what malice is just complete disregard for the facts, a botched investigation, not talking to anyone, just coming up with this random you committed fraud thing out of thin air. So that could be what happened here. It sounds like that's what happened here. I think they were trying to say that he was using the company vehicle or something, or he was going to use it for his vacation or something. I'm not sure. The complaint doesn't say specifically why it was committed, but in reading some articles, it sounds like the basis was related to the vehicle, or that's what they were trying to come up with as the claim for fraud, gross misconduct. And so apparently the jury didn't buy it, and they thought that it was done with actual malice, botched investigation, and it probably pushed some ulterior motives too as to actually terminating him. And the complaint actually had some discrimination claims in there too, failure to accommodate, stuff like that. And I don't know if those gained tractions in that case or not. I don't know if they already won on those claims and just that claim went to the jury, or if they lost on those claims. And that's the only claim that was left for the jury to decide. But with the defamation claim too, kind of looking big picture wise, and I've seen this too in a lot of cases dealing with employees, is workers' compensation. And what I see generally is if you are a 20-year-old, 21, 22, 23, 24, 25-year-old person, maybe even up to 30-ish, if anything happens to you, and you tear your ACL, MCL, break a leg, whatever, and if there's no serious brain damage or injury that's going to affect you for the rest of your life, companies are totally fine with that. They will put up the bill and they'll pay for your surgery, they'll pay for your time off work, and they'll wait for you to come back, and there's usually no drama when you're a younger employee. But when you become a older employee, your body changes and you're not in your 20s anymore, and things start to degenerate. And if you're in your 50s or 60s, then and you get injured at work, what could be like a 1 month recovery for someone in their 20s could be something that could affect this person for the rest of their life, and could make it so they can't work for the rest of their life. So if they're 50 years old and retirement is 65, then that's 15 years of work. If they cannot work, if they're totally disabled, then they're on the hook for paying him every week whatever the workers' comp calculation is for that state, the average weekly wage. which is LeBrow. It's not a lot of money. Workers' comp isn't a great system. It's very pro company, especially in conservative states. But you usually get around $700, $800 a week, but it depends on how much you make too. So if you make less, it could be less than that. And if you make a whole bunch of money, lots of money, and you get hurt at work, there's a cap on how much you can make. And so a lot of people that make a lot of money are out a lot of money getting injured. So companies, I mean, workers' comp in theory should be a very easy process. And really, what the theory is behind it is that we want to make sure that workers are covered when they're injured at work. And it's good for the economy and whatever else. And we don't have all these people destitute and can't pay for their medical bills. Um, and because in most personal injury cases, if I'm not at work and I get injured by somebody in a car accident, I have to prove that other person was negligent. And I've done that. We talk about that in my other podcast about torts and personal injury. And so there's this negligent standard. And so if I can't prove that the other person was negligent, then I can't recover from that other person for my damages. And so if that same principle applied in the workforce and I had to prove that the company was negligent because I was injured, and I mean, in that case, if a semi-truck rear-ended the guy, lucky for him, he could probably prove negligence in that scenario, but not a lot of people are as fortunate, and it's just some tragic accident where someone may or not have been negligent. Or maybe the worker was somewhat negligent too, and they get injured, but then they're out of work and they can't work, and so they lose their job, and so they lose their medical benefits, and they can't pay for themselves, and then things start spiraling out of control, and then you have this person that's completely destitute and can't take care of their injuries. So you want to avoid that. So the theory is that companies are giving up the proof of negligence to and all you have to prove is that you're injured at work. So that sounds way easy. No problem. I was injured at work. Like it happened at work, and so yeah, they should be fairly easy cases. Well, that's not necessarily the case in reality. And actually, quite frankly, I've done some personal injury cases. I've done some workers' comp cases. And from my experience, and I'm coming from a conservative state, but they fight so much harder in workers' compensation cases than they do in personal injury cases. Like, in personal injury cases, you're focused on negligence. Did it happen? Everything like that. And so you think, what can the other side really fight on when it comes to workers' compensation? There's not a whole lot left. Like, did it happen at work or not? But they can still fight one thing. And the one thing is that even though maybe you got injured at work, did you have a pre-existing condition? And that's where they, especially with the old people, that's what they always go for. And they have their medical experts in their pocket. They pay them the money and they will get them to say whatever you want. It sounds crazy, but I'm telling you, it's true. I've come across some really bogus medical evaluations from MDs, and they've come up with some very illogical reasons to claim that stuff didn't happen at work, even though very clear something happened at work or she would not have been where he or she was. So it sounds easy, but they'll fight that pre-existing condition tooth and nail, and they'll find anything in your medical records because they can look at your medical records 10 years back, and they'll say, oh, well, you slipped on a piece of ice, or you talked to your doctor about your shoulder or something. And if there's anything that they can find, any scent of any prior problem that you had with that bodily part, then they'll try and nail you. And even not, even if you don't, they will look at your MRI and they will say, like, if it's a soft tissue thing, they'll be like, wait, like there's some cartilage stuff, and the cartilage was like this. There's some fraying, and that's evidence of degenerative and not something that happened at work. And so you are lying. This injury didn't happen. It was because of something else, and you're just saying that it happened at work. So unfortunately, that is the problem that people have to face, and so what should be a simple case can end up being a more contentious case, a case that can take much more longer to resolve than your typical personal injury case, and because employers don't want you on the books, they don't want to have to pay for you, they don't want to have to pay for your premium, they don't want to they don't want you on their books for the rest of their life, for the rest of your life. And so that's the big picture issue that we have with this case is, and it seems like that's what were trying to allege in the complaint too, is that they wanted him off the books. They didn't want to deal with him now that he was injured, and that there could be accommodations needed. He may not be 100% moving forward, and they may not be able to perform his job at 100% moving forward. And so the big picture is they were just trying to come up with a reason to get him off the books. And so, like I said at the very beginning, like their in-house attorney may have been saying, hey, like, okay, you want him off the books, but you got to come up with a different reason than we're terminating you because you've been injured at work. You got to say. And so I don't know if in-house counsel was involved or not. I have no idea what was happened behind the scenes, and if it was just the supervisor that just wanted them off the books, or just didn't want to deal with someone that was injured. And also, if you're in California, it's definitely more employee friendly, and you're definitely they're more willing to give out verdicts like that than in conservative states and or big damages. More conservative states more juries are more likely to give a lower amount of damages to. And so what he actually won in damages, like actual damages, like lost wages and benefits plus reputation, humiliation, harm to his character, that was $9 million. And so the judge awarded punitive damages, which is like a penalty against Walmart for what they did. And I always tell clients not to bank on punitive damages and think that, hey, I'm going to win, $29 million in punitive damages on my case. And when I evaluate and analyze a case, that's never going through my mind. I'm always looking at the $9 million, the actual damages, because you never know how a judge is going to rule. You never know if that's going to get awarded, and also they can appeal it, and they probably will appeal that award, and it could be reduced. But that's probably a pretty constitutional one. Usually punitive damages should be at least 2, 3 times. 4 times is kind of pushing it, but that's kind of within the limits. If it's anything above that, you could say that that's excessive and unconstitutional, and so that's why a lot of them appeal it. But it seems like 9 million, that's kind of in the times 3 range, times 4-ish range. So they are probably safe with that one. But if they get really, really excessive, then an appeal court could strike it down and say, hey, that's excessive. Because the whole point of punitive damages is to punish the company, but also factors that courts look into is how much does the company make? Can they afford this kind of penalty, or does it completely torpedo them? Obviously, a big company like Walmart, $39 million isn't going to torpedo them, but that's something that courts would analyze. And so if it's way excessive, and if it's a smaller mid-sized company and they get this award and it just completely makes it so they can't operate anymore, judge might say, hey, maybe this is a little excessive here, and it's more to penalize but not to make you not exist anymore. So that's how punitive damages work, how awards work, um, and also that's kind of how big picture we kind of get to this stuff here, and how these scenarios come up, and I'm definitely familiar with these scenarios, and yeah, it's not fair how easy workers' compensation should be in theory, but still companies fight it, which yeah, in my mind isn't fair, because I have had clients where this same scenario has happened where they've trying to get out of workers' comp, they're trying to come up with bogus reasons, they're trying to um, claim that you can work but you really can't, your doctor says you can't, and they're trying to play doctor, or uh, other nitpicky things to claim that, hey, you're not entitled to workers' comp, or hey, we're going to terminate you now. Because if it is a scenario where someone's in their 50s again, and this is their source of income, and then they get terminated, and then they claim that you're not entitled to workers' comp, and you have to fight workers' comp, and you can't work, and you're in the hospital, and you need surgery, and you can't work any other job. I mean, what is your life going to be like moving forward? So I've seen it firsthand, and not a fan of how companies can treat employees so unfairly, when you know at one point you're the top of the class with the company, you're doing everything right, and then another point you're liability, you're a cripple, we don't want you anymore, we want you off the books. So very unfortunate scenario here, but yeah, but that's how it works in with that award. And if you want to know more about defamation and or personal injury, you can look up my podcasts on those as well, and like and subscribe to get more of these legal podcasts, and we'll talk to you next time.